Shocking fact, contradiction to open with. Nnamdi Kanu was convicted and sentenced to life imprisonment on Thursday, and by Friday, before his lawyers could even file the paperwork for an appeal, he was already in a prison more than 700 kilometers from Abuja, in a state he has no documented personal or political connection to. While everyone is talking about whether Kanu is guilty or innocent, nobody is asking why a man who just lost the right to walk free was also in the same 24 hours stripped of practical access to the lawyers who are supposed to help him challenge that verdict. Was this move about prison logistics or about making an appeal as difficult as possible to file?
Federal High Court Abuja Justice James Omotosho found Kanu guilty on 4 of 7 terrorism-related counts, life imprisonment on the lead counts, lesser terms on others. Court explicitly barred Kuje Custodial Center as a destination, citing Kanu's conduct during trial, and ordered DSS to place him in protective custody anywhere else in the country. Within roughly a day, DSS moved him from its own Abuja facility to the Nigerian Correctional Center in Sokoto. His legal consultant, Aloy Ejimako, announced the move publicly. DSS sources separately confirmed it. Established the institutional position, this was a court-sanctioned discretion exercised by the DSS, not an unauthorized act. Note that Kanu currently has no enrolled lead counsel. He has been representing himself since dispensing with his legal team earlier in the trial. That detail changes how serious the distance from lawyers complaint actually is. Ejimako invoked the 1963 precedent. Obafemi Awolowo, convicted of treasonable felony, was deliberately moved to a region considered politically neutral rather than hostile territory. Brief, non-lecturing context, that precedent is being used to argue Nigeria has a tradition of choosing neutral ground for high-profile political prisoners, and that Sokoto breaks with it. Counterpoint, the court's order gave DSS latitude to choose any facility in the country. Sokoto is not outside that mandate, however politically loaded it may feel. But logistics and politics are two different battles, and the next one is being fought entirely on paper, in his appeal. Map the actors: Federal High Court, Sentencing Authority; DSS, Custodial Authority post-verdict; Nigerian Correctional Service, Facility Administration; Court of Appeal, jurisdiction over the pending appeal; ONSA, oversight of any device access granted to Kanu. Constitutional anchor: Section 36 of the 1999 Constitution, fair hearing rights, is the legal hook Kanu's camp is using to argue the transfer impedes due process. Explained plainly, an appeal has procedural deadlines and requires the convict's signature or instructions on filed documents. Physical distance from one's legal team can functionally, not just emotionally, slow that process down. Note the formal limit. The court, not DSS unilaterally, retains oversight, evidenced by the fact Kanu's team was able to file a motion asking for relocation, and a hearing was held on it. The same court that convicted him is also the forum now hearing his request to be moved back closer to Abuja. Justice Omotosho put the Correctional Service and prosecution on notice over that motion in December. The system left itself a release valve. Federal government, a closed chapter on a decade-long internationally watched secession-linked prosecution, removes a galvanizing figure from proximity to Abuja and the Southeast media ecosystem. IPOB and Kanu's support base lose their most visible advocacy access point. Risk of radicalization among supporters who view the transfer as punitive rather than procedural. Traditional and political voices in the Southeast, for example, Umuahia North traditional rulers, have publicly rejected the terrorist framing, a sign the verdict's legitimacy is still contested locally, regardless of the court record. Electoral angle: how the Southeast reads this heading towards 2027, as closure or as grievance to be mobilized. Silent stakeholder to name: the National Assembly and Southeast governors, which have largely avoided direct comment on the custodial question, even as it tests federal-state balance. This is not only a Southeast story, It tests how the federal government handles politically sensitive prisoners nationwide, a precedent every region should be watching.
Precedent danger. If a custodial transfer can functionally limit a convict's appeal access without being formally ruled improper, what does that license in future politically charged cases? Federal-state balance. The choice of Sokoto, a state government has limited say over a federal custodial facility, underscores how centralized this kind of decision-making is. Security implication. Whether the relocation cools or inflames IPOB-linked agitation and sit-at-home enforcement in the Southeast. Diaspora angle. UK, US, Canada. Nigerians abroad tracking this case for two reasons: advocacy networks built around Kanu's cause and the broader signal it sends about how Nigeria treats high-profile dissent, which factors into diaspora sentiment on remittances, investment, and travel risk perception tied to Southeast stability. International dimension. No major formal position yet from the US, UK, EU, AU, or EWAS on the custodial transfer itself, though the broader trial has drawn rights-focused commentary. Flag this as a space to watch rather than overstate. The court itself ruled Kanu unsuitable for Kuje and authorized placement anywhere in the country, given a documented tendency of violence finding by the trial judge. DSS-run facilities are not designed for long-term post-conviction custody. Transferring a convict to the correctional service is the legally correct next step, and Sokoto may simply reflect capacity and security logistics, not targeting. Where the logic strains. Anywhere in the country technically permits Sokoto, but doesn't explain why a location nearest to his counsel and Court of Appeal jurisdiction wasn't prioritized when other options, Kuje aside, existed. The pending relocation hearing itself suggests the courts recognize the access concern has merit. A common misconception to correct. Some social media claims framed the move as a unilateral, unlawful disappearance. The record shows it followed a public judgment, with the destination disclosed within a day and contested through formal court motions, not informal lawyers' speculation alone. Outcome of the pending relocation hearing: will Kanu be moved to Kuje, Kefi, or Suleja, or remain in Sokoto? Whether and how Kanu's appeal is formally filed given the procedural constraints. Any statement from Southeast governors, NASS, or the presidency directly addressing the custodial concern. Confirmation this is escalating. Further legal motions, public statements from traditional rulers or diaspora groups, security incidents linked to IPOB. Sign of quiet resolution. A transfer back to a facility nearer Abuja without further public dispute. Return to the hook. This was not simply about where Kanu sleeps at night. It was about whether the machinery of appeal can function when an inmate is moved far from the lawyers, in the very window when timing matters most. Measured conclusion. The transfer was legally permitted, but it raises a fair process question that the courts themselves are now being asked to settle, and that process, not the headline, is the real story to follow. What ordinary Nigerians can do: follow the appeal proceedings directly rather than second-hand claims, demand transparency on custodial decisions in politically sensitive cases generally, and stay engaged regardless of where one stands on Kanu himself. Invite critical discussion, pushback welcome, but anchored in the court record, not rumor. If you find this analysis helpful, like, subscribe, and share, and I will see you in the next one. Shocking fact, contradiction to open with. Nnamdi Kanu was convicted and sentenced to life imprisonment on Thursday, and by Friday, before his lawyers could even file the paperwork for an appeal, he was already in a prison more than 700 kilometers from Abuja, in a state he has no documented personal or political connection to. While everyone is talking about whether Kanu is guilty or innocent, nobody is asking why a man who just lost the right to walk free was also in the same 24 hours stripped of practical access to the lawyers who are supposed to help him challenge that verdict. Was this move about prison logistics or about making an appeal as difficult as possible to file?